Good morning. Thank you for being here. Today we have excellent panelists that are going to talk about some relevant issues for all our audience and help to the participant in the mood camp. The topic here is digital economy and merger control, lesson for Latin America. Our panelists are William Cavachi, Director of the Competition Law Center at George Washington University and Global Competition Professor of Law and Policy. He also serves as non-executive director of the Competition and Markets Authority CMA board. Thank you, Will. Maximo Morta, research professor at the CRIA, Universidad Pompeu Fabra, and the Barcelona School of Economics. He founded the Master in Competition and Market Regulation and was chief economist of DG Com. Vishal Mehta, partner of Morrison & Forrester Global Antitrust Law Practice Group, based in Washington, D.C., Vishal has extensive experience representing clients before the Federal Trade Commission, FTC, the Department of Justice, DOJ, and the foreign competition authorities in all phases of merger review. Vishal has unique expertise at the intersection of antitrust and technology markets and consults many of the largest technology companies in the world on competition issues relating to digital platforms. Let me start with a brief introduction. The COVID-19 pandemic is impacting digital transformation differently across countries, with rich socioeconomic consequences in Latin America. The digital transformation brings new opportunities for the region to handle with the current crisis and overcome its long-term consequences. The pandemic has driven the digital transformation of society. Home office, online banking, as well as increased e-commerce are just some of the activities that have increased a lot in the last years in Latin America. Even though in different proportions, Mexico, Colombia, Chile, and Brazil are four of the countries in which the digital economy has increased the most. However, the region only have 32 unicorns compared with the USA that have 228 and Europe 166 and China 125. In terms of digital innovation in Latin America, the growth came from a few years ago. However, the pandemic has accelerated the digital transformation of businesses. The pandemic has been an opportunity in terms of digital activity, but also a challenge. Competition in the digital economy has evolved mainly through the incorporation of innovative business models and strategies, including the widespread use of algorithms, information technologies, artificial intelligence, machine learning, and big data. At the center of the disruption lie the big tech companies, due to their controversial business strategies and the possible substantial market power that have achieved over the time. The fast pace of mergers and acquisitions among big tech companies represent a concern for competition authorities in many countries. Latin America is an evolving region for merger control. Mergers and acquisition activity is up greater than 10% year on year. According to a review of cases in 21 jurisdictions in Latin America from 2015 to 2020, almost 60% of the jurisdictions have dealt with matters related to digital markets, most of them concentrated in Brazil, the leader in the matter, Colombia and Chile. The dynamics of the digital economy and the impact of the pandemic on sales has called into question the viability of traditional tools for protecting competition against mergers and acquisitions. The COVID-19 crisis has also raised the challenge of addressing cases involving Philippines defense in uncertain times. In Brazil, the competition law grants the Administrative Council for Economic Defense the prerogative to review any mergers and acquisition even when the mandatory reporting requirements are not activated. This is an important tool for combating such practices. There is no standard regarding the regulatory frameworks in different countries. So what we have in some other jurisdictions? We have a lot to discuss here. So let's start with Will. Bill, thank you for being here. Can you share some US experience about the current bill proposals that are being discussed in the USA Congress, or the challenge in the vertical merger guidelines? And if we have an extra time, can you share with us some killer acquisition in the USR? Thank you, Bill.
The US is in a period of extraordinary upheaval, a level of ferment in the agencies and in the legislature that we have not seen for 50 years. And it promises to bring to bear a wide variety of policymaking tools on the tech sector. One set of developments involves the prosecution of new cases. In the past 12 months, government antitrust agencies at the national and member state level have initiated major monopolization cases against Facebook, Google, Amazon, and Apple. Some of these cases demand, as a remedial solution, the restructuring of these companies and the creation of two or more enterprises as successors to the existing firms. In addition to this remarkable series of litigation initiatives, we have the declaration by the President Biden, in early July, to commit his government to what is called a whole of government approach, in an executive order that calls upon public agencies to undertake over 70 discrete pro-competition policy measures. Among those is a request for the Department of Justice and the Federal Trade Commission to retool all of the government's merger guidelines, to bring their enforcement resources to bear upon dominant positions in the technology sector and in other sectors, and to work with other public agencies to develop pro-competitive policies to make markets more permeable, more open, and more effective by bringing competition policy to bear on all areas of decision-making. The third major frontier of decision-making is the one you mentioned, Anna, which is the possibility of new legislation. 10 years ago in the United States, the tech giants were celebrities. They were viewed as national treasures. When they would appear at a legislative hearing, the questioning would be very light-handed and also almost laudatory, as in, Mr. Zuckerberg, please tell us how you became so wonderful. Mr. Bezos, how could you possibly have developed such a wonderful business as you have? And as soon as these light touch questions were finished, the members of Congress would swarm among the chief executives for photo opportunities. They have gone in a decade from being national treasures to being pariahs. And as recently as this week, with the testimony of a whistleblower attacking Facebook's internal decision-making policies, and as she put it, putting profits ahead of people, Congress has turned in a very significant way against the tech sector. It remains to be seen whether this antipathy will convert itself into new legislative proposals, but there are several serious proposals in the queue. To give the agencies dramatically more resources, 50 to 100% more than they have now in their budgets. To impose severe controls on mergers involving dominant enterprises, and in selected instances to create what amount to be presumptions of illegality for transactions involving companies above a certain size. A third set of proposals would impose severe conduct-related restrictions on dominant firms that go beyond merger control. And the last set of measures would create new ex-ante regulatory regimes to subject the dominant firms to controls on whom they allow to participate on their platforms, the terms on which they do business, the obligation to provide service on a non-discriminatory basis, in some ways to directly borrow techniques that are now embedded in proposals for the DMA in Europe and for the Digital Markets Unit in the United Kingdom. It's difficult to say how soon these measures might become law, what sequence Congress will pursue in embracing them, but what is unmistakable is that the environment is much more welcoming to a host of measures, both in legislation and in litigation. And the last thing I'll mention is that President Biden, I would say to the surprise of the larger competition policy community, is making appointments that bring individuals to the fore who want a fundamental transformation in the US system, grounded in a reassessment of the proper objectives of competition law, to move away from an economic welfare-based analysis under the rubric of consumer welfare, to go beyond the interests of consumers and to focus on a larger notion of citizen welfare. Citizens who want protection, not just as consumers, but as employees in businesses, as owners of small businesses, as residents of communities whose well-being is affected by the behavior of dominant firms, and crucially, as participants in a democratic process. I would say the most famous competition in the person in the world at this moment is a 32-year-old chair of the US Federal Trade Commission, Lina Khan, who 5 years ago was in law school. And now she is the head of the Federal Trade Commission, and she is pressing ahead in a very forceful way to lead the agency in a significantly different direction. One manifestation of this was the FTC's decision by a 3-2 vote on the board of 5 to withdraw from the vertical merger guidelines and to reconsider fundamentally the purposes and the functions of merger law. Along with Lina Khan, we've had the appointment of Tim Wu, who coined the term net neutrality to work in the White House as a senior advisor to the President of the United States. And the US Senate Judiciary Committee this week held its confirmation hearing for Jonathan Cantor to be the head of the antitrust unit of the Department of Justice. Collectively, these appointments foreshadow a significant reorientation of US enforcement policy in many regards to embrace broader enforcement-oriented views, including perspectives that bring to bear a wide variety of egalitarian values that go beyond the traditional welfare framework. I think legislation will be necessary to make this effective because while there have been many critics of this welfare orientation, our courts believe in it. And as recently as this summer, our Supreme Court made clear we still believe in it. We like it. If Congress tells us to do something else, we shall. But until then, we're going to follow the path we have carved out over the last 40 years.
Thank you, Bill. Very interesting your insights about the US experience, which is a reference for Latin America jurisdictions. Now we continue with Massimo Motta. Massimo, can you share with us the EU experience, particularly the MEU and the MEA?
On the DMU, which is a digital markets unit, I know a little bit, but since the UK has decided to move more towards the United States and it's not part of Europe anymore, I do not know whether they want a European who is going to talk about that. Jokes apart, I will tell you a little bit about what I know. Well, first of all, I think that the sort of environment that Bill has described, in which basically the status quo is changing, probably also applies to Europe. Although some of the initiatives are not exactly as forceful as in the United States. But let me sort of try and describe a little bit better the environment in Europe. First of all, I think it's fair to say that the EU was the only jurisdiction where there was an attempt to enforce antitrust in the digital domain by using the abuse of dominance provisions in the treaty. So at the time in which nobody else was considering bringing cases against Google and other of the big tech, the European Commission had actually put forward and had several decisions which it issued against several practices of Google, for instance. They are still under appeal, so we are still waiting for the judgments of the court, which will be very interesting. But this is just to say that we come from a period in which there was an attempt to use antitrust rules and antitrust laws in order to deal with at least some of the practices of big tech. But on the one hand, I think it is fair to say that the people have understood that even if you can try to do something with the traditional abuse of dominance provisions, this type of instrument is limited and also it takes a long time. So just to say something, I think that the Google shopping case more or less officially started in 2010, and now in 2021, we are still that the case that it's under appeal. And this pushed towards the proposal of the Digital Markets Act, on which I'm going to come in a second. On the other hand, there is also another area where the European Commission has basically not intervened at all, which is merger control in the area of big tech. So what does the Digital Market Act proposal do is basically to say, well, competition law provisions are not enough to deal with many of the conduct that these big digital companies are carrying out. So we need something else. So basically what the DMI proposal does is to draw a list of conduct that the big tech, which are designed, say, with the position of gatekeeper, which is to be better defined, should follow, and other practices that they may not follow. So basically a white list and a sort of blacklist. Now, this is a proposal. We have to see how it's going to be in the end, if and how it's going to be approved by the Council and by the European Parliament. But what is clear is that the DMA proposal is basically silent on merger control, which I understand is the main issue of interest also in this panel, in the panel today. And that is a little bit of a problem, as I see it. Now, as people who are listening now know, what has happened in the last 5-6 years is that we have had literally hundreds of acquisitions of big tech, and these have basically almost never been challenged by antitrust authorities around the world, including the European Commission. And this is for different reasons. And one is because sometimes there are notification thresholds which are not even met. And so the European Commission say, even if it was willing to, it would not be able to intervene and review a merger because it goes below the radar of the European Commission, because certain notification thresholds, which are mainly based on turnover, are not met. And the other big issue is clearly the burden and the standard of proof, which is that even if the European Commission starts to review a merger, then the next issue is, can they do something about it? And would the court be ready to accept some possible negative decisions of the European Commission? Say, if the European Commission decides to block a certain merger, would the court follow? So this is related also to the last issues that Bill was mentioning, which is we have to understand how then the court, in the light of the existing legal provisions and in the light of the jurisprudence, what the court can say about certain issues. Now, the DMA is basically silent. The DMA proposal is basically silent on merger control for different reasons. Some people have said that it was not possible to intervene from the legal point of view within that context, as other people disagree, but be as it may, basically there is nothing about that. There is just a generic obligation for the companies for the big tech to inform the European Commission about the merger, which is nothing, right? So the European Commission would hear that Google or Facebook or Amazon or Apple have bought some companies, but would not be able to intervene. Now, the European Commission has new guidelines on an article which regulates the possibility for member states to refer mergers. So this means that the European Commission has found a way which perhaps it might be able to review some mergers if the member states are going to say to the Commission, please, Commission, review this merger. Okay, But this leaves open another issue, which is in the light of the existing rules, in the light of the fact that the European Commission has the burden of proof, and especially when it comes to, say, mergers with potential competitors, would the Commission be able to block mergers which are potentially anti-competitive? So that is one of the big issues, and this is an issue on which, in my opinion, something more should be done, possibly at the level of the DMA, because if the provisions do not, the legal provisions do not change, I find it difficult for the European Commission to block mergers, even if it were one way or the other notified to it. Now, I understand talking about, I will not talk about the difference between the UK proposals and the European proposal, and just quickly so that I don't take too much of our time. But I understand also that the similar issues also arise in the UK. In the UK, there is something which has more bite, which is the fact that according to the ideas at the moment, the digital market unit can designate a platform with a strategic market status, and that would oblige that firm to notify its merger. So at that point, the digital markets unit can intervene. There is still not much in terms of a different set of rules with respect to burden and standard of proofs. Although what I've seen is that the UK has been bolder in trying to go after digital mergers than the European Commission. And in particular, I would mention two things. The first one is that in the merger guidelines, they stress the fact that they are basically ready to take more risks, that the CMA is ready to take more risk and to deal also with cases in which there is notable uncertainty. This is again without changing the standard of proof, but there is a lot of language to the extent pointing to the fact that they are ready to look at situations in which there is much more uncertainty, not to limit themselves only to static competition, but to look further away into the future, etc. So this is one signal that has been sent by the CMA. And also another thing that they have done, for instance, in a recent challenge that, well, the case is still open, but there has been a preliminary decision by the CMA that the Facebook-Giphy merger is anti-competitive. And basically they are following in that particular merger, in that preliminary decision at least, they are following up on what the guidelines their guidelines are saying. That is that they are trying to push for much more forward-looking type of analysis, and they are also ready to take more risk and to take on more uncertainty. And with this, I would stop on these preliminary remarks. Thank you.
Thank you, Massimo. Well, before we continue with some questions, please, Vishal, can you talk about the challenge the companies or clients are facing with international mergers and divergent approaches?
Sure, and thank you so much for having me, and thanks very much to my fellow panelists and the very thorough and impressive and in some ways thrilling backdrop that you've just laid out. And I will layer on with some brief remarks about the view from the practitioner's perspective, maybe starting in the U.S., but of course from a global standpoint as well. I think for all the reasons you've just heard from Massimo and Bill, there is an extraordinary amount of uncertainty with respect to the regulatory environment in which companies are operating, both in the U.S. and abroad. Adding to some of the perspective and current developments that the bill outlined in the U.S., there have already been changes that we're seeing taking place in real time that really do impact the way companies are doing business, both with respect to M&A and executing their business strategy. Some of these changes, like changes to the prior approval policy of the Federal Trade Commission, the ability for the FTC to issue, for the agencies to issue warning letters that effectively put companies on notice that the investigation into their prospective merger technically remains open indefinitely, to the inclusion of questions in the second request process that get to non-competition factors, such as impact on labor issues. So these are what's been described by one FTC commissioner as death by 1,000 cuts, which in some ways almost underestimates the impact that these real-time developments have on businesses that are undertaking M&A and other business conduct in the current regulatory environment. So all that's to say, there's quite a bit of uncertainty as to what the rules are now, how those rules impact M&A activity and other strategic conduct that businesses are engaging in. To say nothing of the very significant changes that seem to be on the horizon, both in the U.S. and as Massimo just described, in the EU and other jurisdictions worldwide, in terms of new legislation and new policy. So that is a difficult environment in which to operate, and it has a very real impact on the strategic decision making of businesses. On the other hand, we do see that despite these now I'm not so sure we can call them even new developments, these developments which we are increasingly accustomed to, M&A activity continues to surge both in the US and worldwide, which brings up a question as to whether some of these initial forays into changes in competition enforcement, to what extent they might have a deterrent effect on M&A and other activity. One other point I'll make before opening it up to the panel is that it's very important to consider. This panel, we're principally focused on digital markets. Indeed, many of the policy reforms and that are being considered in jurisdictions around the world are principally directed at correcting potential market distortions in those areas, specific to digital markets, specific to large digital platforms. But again, from a practical perspective, these are all, and as is, I think, quite evident in the ongoing discussions around in the EU around digital markets regulation. These changes have impact beyond just digital markets, to companies that are operating in all sectors of the global economy. So that's an important, I think that's an important consideration to keep in mind as enforcers and legislators move forward in taking the competition toolkit into the future to regulate the digital markets.
Thank you so much for your perspective. Well, we have some questions here. So we know that in Latin America, we have a different scenario from you and from the United States. So please, Bill, I heard one day that you said that it is important the time, but also where we go. So Based on your experience, what are the main challenges in digital markets that we should address in terms of competition in conjunction of promoting innovation and economic growth here in Latin America?
Anna, if I can come in on that with a couple of thoughts, and my colleagues have already mentioned these. One that Massimo underscored is speed. That is, are you able to intervene in a timely manner? If we take the litigation developments that Vishal and I were referring to in the United States and the litigation timeline that Massimo mentioned with this powerful example of the Google shopping case, we have traditional abusive dominance litigation technology that takes many years to deliver a result. I'll take one example in the US. This is the Department of Justice lawsuit against Google, which seeks the restructuring of the company. The Department of Justice has been joined by a number of member state governments as well. The tentative date for the trial in that case to begin is September 2023. That's 2 years from now. If it went by that schedule, the result at the court of first instance stage would come to a conclusion in the middle of 2024, an inevitable round of appeals to the US Court of Appeals for the District of Columbia. We're in 2025. And then if the Supreme Court were to decide to weigh in with its own views, we're in 2026. That's 5 years from now. And we might ask ourselves, what happens in a sector featuring this degree of dynamism? It hasn't taken things up to the 10-year limit that Massimo described for Google Shopping, but I think a genuine question about the application of traditional antitrust technology is whether it is the equivalent of riding a bicycle to catch up with a Formula One racer. A second challenge is what I call a knowledge challenge. That is, do agencies have the capability to understand the phenomena that they're addressing, to do an accurate diagnosis, to select an optimal treatment, and then to supervise its implementation over time? I'm on the board of the UK Competition and Markets Authority as a non-executive director. I don't speak on their behalf, but I'm very impressed with what the CMA has done in the last 5 years to attempt to build the internal capability to analyze these issues more effectively. They built a team of data analysts, computer scientists, and related professionals, a team of 40, to do work in this area. I can see internally at the CMA it's making a great difference. That is, instead of relying on lawyers and economists, as brilliant as they may be, and of course they are, to do good analytical work here, it's evident in the CMA's experience that if you don't develop a different set of skills, you are terribly limited in your capacity independently to form a sound judgment about what's taking place, even if you draw in other resources from the outside. And I think the third issue, again, both of my colleagues have mentioned, which is if you develop ex-ante regulatory tools, which are ideal, and we have two interesting experiments emerging in the UK and in Europe, the DMA that adopts a set of overarching principles for all affected firms. The UK is attempting to develop a tailored code of conduct for each platform according to the distinct characteristics of each platform and the business model that supports it. I think what we will be going through inevitably is a significant period of experimentation. A challenge for larger policymaking, just mentioned by Vishal, is if you have several of these experiments unfolding across major jurisdictions, are the jurisdictions speaking to each other about what they're doing? Are they candidly discussing the strengths and weaknesses of the approaches they've taken? Do they have some mechanism in place to identify as we go along how we're doing, what's working, what's not? And we haven't even mentioned the extent to which a jurisdiction such as the People's Republic of China is taking major strides in the direction of developing its own regulatory framework. So achieving coherence, identifying superior techniques amid all of this experimentation is a very big challenge for the system. So speed, knowledge, multiplicity.
Thank you, Bill. Maximo, do you have a complementary from this question?
Yeah, I perfectly agree with Bill, so I will indeed try to make some complementary remarks. So one is the fact that you mentioned what can we do to achieve more growth and more innovation in Latin America. And here, I think that it's important to understand that in order to be successful also in the digital area, it is important to act not only on the digital sector. So this is to say that there are lots of things which might drive more growth and more innovation, but and which come from all sorts of other things. Now, I would not want to talk about education, about labor markets, etc. But for sure, to guarantee that there is serious antitrust action to keep markets open, for instance, in the financial market, I think it's very important and very relevant, because if you don't have a regulation and the competition enforcement which keeps all the markets open, then this is going to be problematic in all the markets, including the digital one. So this is a comment which is a little bit more general, but just put things in perspective. But I think it matters. The second one is that there is clearly an issue when it comes to big tech conduct or mergers. There is clearly an issue which is what is global and what is local, in the sense that a firm which is acting everywhere in the world, then an agency basically is saying, well, what can I do about Facebook, WhatsApp? If I am in Peru or in Mexico or in Colombia, how can I do something about it? Now, for sure, it is clear that there are some of these cases which are naturally more global. But I wouldn't underestimate the fact that if you bring challenges from different jurisdictions, then the case would also become stronger. I've seen also in my little experience as an enforcer, talking to colleagues who were in smaller agencies than the European Commission, I basically saw many of these colleagues who were basically bullied by the company, saying, well, you are, say, in country X. Country X is very small. What can you do at your agency? We don't care about you. In any case, the US and Europe are not doing anything, so why should you? So I think that you shouldn't pay too much attention to this. You should try to do action nonetheless. And there it becomes important what Bill said in a slightly different context, because he was talking about regulatory experiments. But I think that coordinating with other agencies and keeping a continual interaction and feedback with the other agencies is very important, also for global cases. Plus, there will be some cases which are naturally local, because if big tech is going to take over a company which has a very strong presence in Latin America, then you cannot expect any US or European agency to intervene. You have to do it yourself, and you can have an impact. And we saw, for instance, in the case of Mexico, I don't want to enter into a discussion about the case, which I know that has been read as controversial. I tend to side with the COFECE, but I don't want to enter into that. But we have seen a case which was first Walmart and Corner Shop. Corner Shop was a company which had an important position in at least 2 countries in Latin America and nowhere else. So there, it's Latin American agencies which need to intervene. Finally, and I conclude with these complementary remarks, just to mention that we have seen that a lot of what is happening now, a lot of the action which is happening in the digital markets is related to data. Okay? And there, I think that competition agencies in Latin America and privacy regulators, to the extent that they exist, or legislators, whatever it is, should try to promote more protection of privacy at the local level. That is, each agency should protect its domestic citizens so that basically the data that they have are not going to be basically shared or owned by the big tech, but they can be controlled by the consumers, or they can be regulated by local agencies. This is an area in which I think it is pretty important. We have seen in Europe there have been some national jurisdictions which have intervened in this area. So, for instance, Germany towards Facebook, and that's something that, in my view, should be considered. Thanks.
Thank you, Massimo. Michelle, in your perspective, do you think you have another thought about that?
Sure, happy to just layer on and respond to Bill or add to what they've so thoughtfully laid out. I agree that from even from the company's perspective, and by companies we're talking about some of the most the most innovative companies in the world, not just the big not just the large digital platforms, but so many other companies as well. That speed and the pace at which antitrust enforcement, be it ex ante enforcement or the more lengthy vectors of enforcement that Massimo and Bill have spoken to, the time which those takes is critically important. From the enforcer's perspective, by the end of pick your litigation matter, or by the appeal stage, the proposed remedy might be moot. Because we all may be living in the metaverse, and companies may have innovated around the issue in any particular given enforcement action. But it's also important for the companies to understand what the rules of the road are, and I think the developments that are taking place with respect to regulation will be helpful to the extent they are moving at a quicker pace than some of the court cases we're seeing. Companies are faced with the question each day, when they're looking 5 years out and executing their business strategy, what will be able to be the rules? So what are the rules of the road, not just now, but 5 years from now, given that we are talking about the innovators, and that right now is a quite an unpredictable environment. And so it really raises the question of, what does the company do? Try to read the crystal ball, or innovate and move forward the best way they know how, until some of those rules are clarified. I also think really wholeheartedly agree with Massimo's theme, if you will, that the local matters. To some extent, the tools that we're talking about are broadly applicable across jurisdictions, but just to riff on Massimo's concept a bit, the enforcement, be it in Latin America or any other jurisdiction, to take into account the market realities at a more local level. To simplify it grossly, even a company that might be dominant clearly dominant in another jurisdiction may not be in a Latin American jurisdiction. So, but on a broader scale, what are the market realities? And one illustration of this, for instance, is in the U.S. Since the beginning of 2021, the agency suspended the grants of early termination of the initial 30-day HSR waiting period. And that's, really has significant impact on the, vast majority of transactions that are notified to the antitrust agencies that are typically, that previously received early termination and pose no competitive concern whatsoever. Many of these are, financial transactions, minority investments by private equity companies and other investment funds that involve no competitive overlap whatsoever. So now, from a timing perspective, those deals are, in the initial 30-day period are on, from a temporal perspective, equal footing to a deal that, than a 3-2 merger that's, facing a lengthy review. Pivoting to Latin America, to the extent that Latin American jurisdictions may incorporate similar tools to, to broaden their toolkit with respect to merger review and ensure that they're not missing potentially anti-competitive transactions that may not, trigger the current notification thresholds. Query whether whether it makes sense to implement, filters like we have, recently implemented in the United States, and raises the question of, in a given economy that has different market dynamics, in which there is, a surge in venture investment, a lot of investment coming in, a growing number of unicorns and dynamic startups. The enforcement toolkit should be calibrated in such a way to take into account the market realities in that region, in that jurisdiction, and not chill helpful pro-competitive economic activity. A short way to say that is, one size. It is important for competition enforcement authorities, in order to achieve speed and to communicate. But at the end of the day, it's not and to leverage the work that agencies like the Commission and others that have been ahead of these issues, to leverage that good work, but one size ultimately doesn't fit all.
Thank you, Michelle. Well, I want to change just a little in this question, because I want to first listen to Michelle, and then we are going to listen to Maximum and Bill first. Michelle, on the topic of acquisition, many of the digital companies arise with the idea of being acquired or financed by established companies or large investors. In your perspective, how can we meet this type of needs without affecting the competition process?
Thanks. That's a good question, and I think it's a difficult balancing act. And I do think, to my earlier point, one way to do it is to take into account the market realities, of the particular jurisdiction or region. So to your point, there in the U.S. at least is, I think, increasing level of scrutiny, or we may anticipate a greater level of scrutiny in the future on financial deals, and there might there's enforcers are asking more questions about the incentives of financial buyers as opposed to other buyers, and whether those are aligned with with antitrust goals. But at the end of the day, particularly right now, in light of what's occurring in Latin America with all the new investment coming in, you need to take into account the extent to which the prospect of exit and being bought by a potentially a larger company is a huge driving force in innovation and investment in the most innovative companies in the world. So it's important to make sure to balance that incentive with trying to regulate potential anti-competitive conduct, be it through some sort of serial acquisitions or other different types of M&A conduct that we might see. I think it's important to not regulate in such a way that we would discourage, discourage investment and discourage innovation, particularly in markets in which, in which there's we're seeing a huge uptick in that type of economic activity.
If I may, on this topic.
Yes, please.
So I think nobody is actually proposing, at least, nobody in her right mind or his right mind, to prohibit all of the mergers of startups. Nor is anybody, I think, shouldn't be thought of like preventing Facebook, Amazon, and Google not to take over any startup. They, in many situations, as I said before, they have taken up dozens, literally, firms. Some of these were, just doing complementary tools, inputs, and they were clearly not anti-competitive at all. Right. So I think the first thing to recognize is this, that, some of these might actually be good, but when there is uncertainty and when there is the possibility that they might be anti-competitive, for instance, because this might develop into a competitor, then in that case, you have to intervene. But if you're going to develop into a possible competitor of Facebook, this doesn't mean that no other big tech could actually buy you. So the fact that we are saying that we are going to prevent Facebook from buying WhatsApp or from buying Instagram, say, it doesn't mean that no other company can actually buy WhatsApp or Instagram. I think this is very important. Now, and also there is, if you think of some cases, take Google Waze, for instance. Waze had possible acquirer. They end up with Google because Google was the one which was offering the most. But why they were offering, more than the others? Because they anticipated that, by getting rid of Waze as a competitor, they basically could continue to monopolize, the Maps apps. Okay, but somebody else could have also bought Waze. Okay, so and that is the sort of perspective that we should have. Not that we have to block any acquisition of startups, but that just those, those startups which will have the possibility to develop into a potential competitor. And there, as I said before, we should be ready to take risk. Also, if the probability is small, but there is a probability that one is going to develop into the next social network, I think we shouldn't allow Facebook to take it over.
Thank you, Massimo. Bill, do you have something else to talk about in this topic?
In one set of cures that we could see would come in the form of new legislation that would establish absolute or rebuttable presumptions that firms above a certain size threshold could not acquire startups. And those might be categorical. My own guess is that new legislation does not come in the United States to control mergers for perhaps another 12 months, if at all, next year. There's a big clash in the Congress about whether new measures are needed just to deal with the familiar four horsemen of the apocalypse, or to deal with a larger range of enterprises. And it's simply not clear when legislation is going to come. To me, that means for perhaps the coming year, what the public agencies do, they will have to do through litigation, through the prosecution of cases. What can we expect in this domain of policy? One, we can expect to see a dramatic change in the risk appetite of the Federal Trade Commission and the Department of Justice. Massimo mentioned the risk calculus that agencies perform. I mean, we can ask the interesting question of how did the Federal Trade Commission and the United Kingdom Office of Fair Trading allow Facebook to buy Instagram? How did the Federal Trade Commission and the European Commission allow Google to buy DoubleClick? I suspect an answer in both instances was the sense we could bring that case, but we're probably going to lose. And what is the point of a glorious defeat? I think the state of mind now of the US agencies, at least, is that taking more chances in the courts is a legitimate and necessary component of merger enforcement policy. An interesting test of this is the acquisition by Amazon of MGM Studios, the movie producer. This is not a small startup, to be sure. MGM is not a nascent competitor, yet it does deal with what we might call a largely conglomerate transaction, perhaps with some vertical features, the type of deal that US authorities for most of the past 40 years have walked away from, perhaps occasionally with behavioral controls embedded in an order. I think what we're going to see is the US agencies being willing to test these cases more. Unmistakably, the view at the FTC is that the failure to attack the Instagram transaction was a grievous lapse. And to have relied on the documentary records that the commission had its hands on, revealing the concerns that Facebook and its chief executive officer had about the capacity of Instagram to emerge as an independent threat to Facebook. I think what we'll see in the US is a testing of notions of potential competition, conglomerate acquisitions, theories that have not worked well in courts, but the agencies bringing to bear more fortitude in bringing those cases, and perhaps being willing to rely on a new collection of arguments that have not been fully tested in the courts, with the clear understanding that these are risky cases, that the courts don't necessarily believe these theories, with the idea that if the courts repudiate the Department of Justice and the FTC, that assists you in going to the Congress and saying, we tried our best, the tools aren't working, this shows that we need new legislation. And by the way, an assumption in this is a point that Massimo referred to, which is the view that it's true that maybe the big guys will not be the exit path for the startups, but there are lots of other companies out there that might buy them. And the benefits in preserving a greater degree of independent inventive activity will easily outweigh the disincentive effects of telling new entrepreneurs that no, Facebook, Apple, Amazon, and Google will not be coming to your doorstep with an offer, but someone else might do it.
Thank you so much, Bill. Well, related with this topic, and to put the traditional markets here, Massimo, we have observed that many digital companies have gone for the acquisition of established brick and mortar companies. What do you think of the concentration of or acquisition of dominant companies in that brick and mortar markets of new digital companies?
I think, well, we have seen digital companies trying to buy brick and mortar companies. We have seen, as I mentioned before, Walmart corner shop, something which was the other way around. Let me make two remarks. The first one is that in some cases, we cannot exclude that it is going to be efficient because of complementarities, because of synergies, etc. But we have to scrutinize those mergers. I think that's one thing which is very, very important, is that just the fact that they are in different markets or they are not competitor today is no justification for accepting that merger. So that's the first thing that I wanted to say. The second thing, which it's a little bit broader. And I think it's also related to something that Bill said at the very beginning, which is, which sort of preoccupations do we have? And that is that we see that digital companies, the big tech, at least, they are gradually expanding their areas of activities. in brick and mortar, but also in other areas. Okay, and so, for instance, we are expanding into insurance, we are expanding into finance, we are expanding into health. Okay, now this is a development which is worrying me, and is worrying me a lot. Not only as somebody who is interested in economic efficiency, but also as a citizen, because we might end up in a world in which I am going to be denied, say, health insurance because Google owns the insurance company, and they can see from my search that I have investigated keywords such as, I don't know, heart attacks or things like that. Or that, they know that I have been watching Formula One competition, and so they now start to be worried about my behavior when I'm driving, and therefore they are going to deny a car insurer to me. So this is a sort of preoccupation which I think we need to take on board. I do not know to what extent this can be covered by the usual economic efficiency slash economic welfare categories and standards, but I think something that we should reflect upon is this one. And personally, I would go in towards a situation in which we have what in the US are called line of business restrictions, in order to avoid this big tech entering into lots of different spheres of economic and non-economic activities, which ultimately can also have a huge impact on politics, democracy, etc.
Thank you, Maximo. You talk about data. What tools can be employed to promote data privacy? Because you talk about individual controls. Do you have something?
I wasn't sure if that one was for me, but just really quickly before pivoting to data privacy, if I may, just wanted to go back to the topic of acquisitions of nascent competitors or potential competitors that Bill was speaking about. In some ways, it really raises another temporal question. Do you the enforcers want to be too early or too late? And as Bill described, in light of the transactions like Facebook, Instagram, and WhatsApp, the U.S. agencies seem to have arrived at the conclusion that we would rather, and Massimo spoke to this sort of risk balancing as well, that would rather be too early, because look what happened with Facebook and WhatsApp. And that sort of raises a question of even while that approach might suit the U.S. enforcers and enforcers in other jurisdictions, to what extent it makes sense for for other jurisdictions and other economies that may make that different choice even today. And even take into account the clear issues, competition issues raised by digital platforms and in technology markets. So just wanted to raise that and not answer it, but raise it. While that might be a suitable and desirable approach for one agency in one jurisdiction, like the U.S. antitrust enforcement authorities, would that approach make sense in perhaps another jurisdiction?
Was the data question addressed to me?
Sorry. Yes, that question was for you, but before that, Bill, do you have some thoughts about the last question?
Just that I think that what is striking, certainly in the US at the moment, in looking at mergers and evaluating them is a change in attitude that has two elements I'll mention now. First, a disbelief that efficiencies routinely are realized in practice, that the efficiency gains offered by the merging parties truly come to life after the merger, or could not come to life through another path. The second belief, and I think this is reinforced by the testimony of the whistleblower at Facebook this week, is that these companies have lost their capacity to manage their own operations effectively, that they become so big, they have grown so fast that the limits of human capacity to impose important controls related, for example, to data protection and privacy, that those limits have been surpassed, and that these are mechanisms that in a basic sense defy effective human control, with the consequence that instead of companies making lots of acquisitions and then quickly retrofitting all of their systems to deal with data protection issues, that they have set aside a number of management tasks to attend to later, and later never comes. Later does not come soon enough. And that what you have is simply because of the scale, speed of operation of these enterprises, that they defy effective human control. And that, I believe, is going to be imparting into the policy debate and calculus greater confidence on the part of those who want to impose controls on size. Now do controls on corporate size solve the privacy and data protection problem? Not necessarily, especially with respect to the social networks. But recent events, I think, are causing elected officials and enforcement authorities to rethink whether or not the path of growth that we've seen in the sector has been healthy.
Thank you, Bill. Maximo, well, yes, you talk about the data privacy and also the risk that maybe the regulators or the competition agency have to take. So what do you think, or what tools can be employed to promote that data privacy?
I think that the most jurisdictions and most countries have been too timid in protecting the privacy and the data of their consumers, and I think that they should devote much more effort into that. Now, there are a few principles which I think they are important, and then there are lots of technical and technological issues which are very complex or which I'm not an expert, but even if I was an expert, I wouldn't be able to say. But I think that there are two principles which are very important, are the principle of data portability. That is, well, first of all, that the consumers should know what are the data that they make available and should have a say about what they do. And that basically the default should be that the consumers do not give permission for their data to be used elsewhere than for the particular purpose that they are using. So this is one principle. The other one, as I was saying, is the principle of data portability. That is that the owner of your data should be you and not the company which is to which you have allowed to use your data when you are going to the platform. And then there is another principle which is important, which is data interoperability. That is that there should be the possibility, if you, consumer, decide to change from one platform that you are patronizing now, that you're using now, to another one, you should be able to port your data to the other platform, and therefore there should be an issue of of interoperability being allowed and possible, because otherwise this cost of switching from one platform to the other would be enormous, and that would protect the incumbent companies.
Thank you, Maximo. Vishal, in your perspective, what do you think about the regulation of that?
Agree with agree with the objectives that that Massimo just laid out. I think that from my perspective, in the U.S. And I wonder what Bill thinks about this as well. There may be such an intense focus on antitrust enforcement, and frankly, compounded by real social and political will to intensify antitrust enforcement. That given the overlap of antitrust and privacy considerations, there perhaps is not enough being done on on the pure play privacy side to implement the types of protections and that Massimo outlined that I agree are necessary. And so, as antitrust really takes up a lot of the oxygen in the room, and by the room I mean the legislative sphere and the halls of government in which these competition changes are being discussed. I wonder whether enough attention is being and wherewithal is being devoted to privacy protections, separate and apart from the antitrust issues raised by big data, so to speak, to make sure that consumers are protected. I think there's been some major there's been some significant enforcement actions that some FTC enforcers like the against Facebook that some FTC enforcers have characterized as a drop in the bucket, but I don't see the same legislative will around privacy regulations as we're currently seeing a surge of on the antitrust side.
Thank you so much. Bill, do you want to add something about this topic?
Vishal has so completely pointed to a terrible weakness in the U.S. regime. The U.S. does not have a comprehensive data protection regime. It has relied on the Federal Trade Commission through a variety of creative steps over the past 50 years to create a framework for data protection, but it has lots of holes in it. And the FTC has become the leading US data protection authority at the national level, but the total number of employees at the FTC who do data protection related work numbers about 60. One digit at least is missing for a country the size of the United States with its economy. You probably need a unit with at least 600 people to do this type of work and to do it effectively. So there's a terrible weakness in the legislative framework, and there is a weakness in the dedication of personnel to do the job. This is the typical US habit of wanting to drive a state-of-the-art Mercedes sedan, but as taxpayers wanting to pay for a fully depreciated Chevrolet. So if we want effective policy here, we have to be willing to make the commitment. Now, our Congress, I think, especially motivated by the Facebook testimony over the past week, appears to be drawing renewed commitment to come forward with the necessary comprehensive legislative framework and the resources to make it work. But to go to a point that Massimo was making before as well, I think to do this work well in dealing with the issues we've been talking about will require a different orientation on the part of the public regulators to recognize the relationship across the fields of competition law, traditional data protection law, and what might be called consumer protection law separately, and to notice important policy complementarities, to notice some potential frictions, but to develop a comprehensive approach, which is one objective of the new FTC chair in her latest set of policy priority statements. I think, among other things, this is going to place an enormous challenge in the path of our behavioral economists and others to decide what remedies are going to work best. The framework that Massimo mentioned, I think, is a great place to start. More human control over data, which requires knowing what's out there, along with tools to direct the way in which it is used, and indeed, in specific instances, to carry it away with you. What kind of disclosure mechanisms will we design to tell each of us what it is there, so that companies give us a clear, comprehensible statement of what's there, and then a choice architecture, to use the language of behavioral economics, that gives us a path where we select what we want done, how we want it to take place, and last, an effective enforcement framework, well-resourced by public authorities, who make sure that what the enterprises tell us about what they're doing and what safeguards they're providing actually corresponds with the truth, so that there is effective enforcement as well.
Thank you so much, Bill. Well, the time is almost over. Maximo, do you have some concluding thoughts?
I think to the extent that there is somebody who is going to work now in antitrust agencies, or will work in antitrust agencies, and as a corollary of what you have heard from this panel, I think that you should put a lot more energy into challenging possible antitrust violations and into challenging mergers which might look suspicious. And this is beyond the digital sector, because I think in Latin America, I've seen, in particular talking about mergers, that antitrust agencies have typically been very timid in trying to challenge mergers. And I'm not just talking about digitals. And as you know, in many jurisdictions, there is not even the possibility to act in a preventative way towards merger control. So I think this is, especially because we know that it's difficult afterwards to intervene on abuse of dominance position and possibly anti-competitive behavior. I think we have to put more attention into the review of mergers in order to guarantee that there is going to be more competition in the markets.
Thank you, Maximo. Bill, your final thoughts, please.
An observation that goes back to the opening of our session about the role of the United States in the hemisphere in particular. I think for a good part of the modern era, a message that US regulators have given to Latin American authorities is one of caution. That you should be wary about making mistakes and intervening too much. That by intervening too quickly, too aggressively, you chill competition and you get in the way. I think a new message will be coming from the United States through the hemisphere. And the message will be, first, the mistakes you make in not intervening are at least as important as the mistakes you make in intervening too much. And to take on the advice that Massimo just suggested which is, do not be timid about intervening. And that we, the United States, apologize for the caution that we have inspired in so many systems. And instead of being a brake on the vehicle of enforcement, we are now willing to be an accelerator. We have moved our foot, and we encourage you to be bolder. We will back you up, and we will give you our support in doing more ambitious things. And that is a notable change in the tone and the content of guidance that the United States has given to its colleagues throughout the hemisphere. So as individual competition authorities seek to do more, the United States is not going to be standing behind them saying, be careful, you can make a mistake. The United States is going to be saying, good for you. Bon chance. Vaya con Dios. Go ahead, do it, do more of it, and don't be afraid of being scolded by us.
Thank you so much, Bill. Vishal, do you want to say something, please?
You know, I don't know how I can top that one, Bill. That had such a great conclusory feel to it. But just to add on, I think you know, I'm very preoccupied with like the temporal aspect of this, as I've touched on a few times. And so, as Bill said at the beginning, you know, time is of the essence and an important thing to keep in mind when crafting, when crafting regulation or thinking about what antitrust enforcement should look like. It's important for the enforcers to make sure that the competition problems that they're trying to solve are not obsolete by the time that they get around to solving them. And it's important for companies in order to understand the landscape in which they're operating, not just today, but as they look into, to innovating and executing their business plans several years in the future. I think to accelerate that timetable for jurisdictions, frankly, including everybody's, trailing the EU to some extent in this regard, but to jurisdictions that are trying to understand what changes they should implement, that are looking to other jurisdictions and communicating with other enforcement authorities to understand what they should be doing. I think it's important for that communication to occur and for those learnings to be leveraged in order to get there, to get to the right regulation quickly. And I think the last thing I would touch on is in crafting the right tools to address the competition problems presented by digital platforms and digital markets, to think carefully about the potential consequences or benefits to innovation. And that's fundamentally what we talk about when we're talking about technology companies, and to also understand the potential externalities, if you will, as to with respect to other industries outside of tech, and to craft the tools to ensure competition in a holistic way beyond technology markets themselves.
Thank you so much, Vishal. Well, there's no doubt that merger control is one of many pillars to deal with competition policy issues in digital economy. We need an effective merger control, but we have some other competition problems that arise and need to be addressed. The question is, do we need ex-ante regulation, and what are the consequences? Or do we need ex-post antitrust control, which is also to be difficult to implement? So I think that competition agencies have a lot of work ahead of us, and to think about market efficiencies and consumer welfare in these new times. So thank you so much for the panelists. Thank you.
Thank you, Ana.
Thank you very much.
Thank you very much.
Thank you.